Welcome back to the Accounting Working Group podcast. I'm your host, Stein Smith, and I am absolutely thrilled to have on the podcast Adam Goldberg this month, who is the regulatory subject matter expert at S&P Global Market Intelligence. So, Adam, it's a absolute pleasure to have you on the podcast. There is a lot to talk about from a compliance point of view lately, but prior to doing all of that, why don't you give us a introduction of you and sort of what your role currently entails right now?
Sure. So my name is Adam Goldberg, and I am as Sean said, I am the regulatory subject matter expert for the Enterprise Solutions Group at S&P Global Market Intelligence. In that role, my job is to basically track new regulations that might affect our business and affect our clients. I offer briefings and consulting both inside S&P Market Intelligence internally to guide product development, and then additionally to clients to help them comply with new regulations as they come out. And that's actually one of the reasons that crypto and digital assets kind of fell into my portfolio, starting a few years ago, prior to crypto winter, when everything was kind of super hot in the space and there was a ton of interest. I was told by some of my senior executives to start boning up on kind of different regulations that could affect crypto and digital assets. And that's only continued in the last few years. So definitely been an active WSBA participant, as well as done kind of numerous panels and other briefings and webinars for people on how different regulations could potentially affect the crypto space. And I imagine we'll be talking about some of those today as well.
Yes, absolutely. So it's probably fair to say that right now you're a pretty busy guy.
Yeah, well, the Supreme Court seems to have given us a lot to work with. Congress has taken a little bit of a break over the summer, so definitely a busy end of term.
Okay. And so, going back to that comment about Congress, right? After really multiple years of very sort of limited action out of Congress, there was a flurry of activity in May and June of this current year, right? There were some bills put forward, were voted on, Fit 21. Both houses of Congress tried to undo SAB 121. And there have been multiple bills put forward around trying to regulate certain aspects of the broader crypto asset marketplace. And so, based on your insights and sort of your expertise and your sort of understanding of all this, what do you think about this sort of current uptick in action?
So I think there's two things to understand that's going on. So firstly, there has been a wealth of bipartisan interest in doing something related to crypto and digital assets. I think for most of us, the hope would have been that there would have been some kind of stablecoin bill or regulation that would have come out in the last couple of years that could have got through Congress. I think in an ideal world, all of us would hope for something akin to the MiCA legislation that has passed the European Union, which sets an overall regulatory framework for crypto and digital assets in the United States. That has proved increasingly challenging to get through Congress. And unfortunately, since we're in the second half of an election year at this point, with less than 6 months to go till the November 2024 presidential election, it is very unlikely that we see kind of any of those sweeping market regulatory bills that set up a regulatory framework for crypto and digital assets in the near term. But there has been a flurry of activity, and I think it's best to try and contextualize that activity. So first off, I think it was very impressive to see that there were 60 votes in the Senate for repealing SAB 121. Obviously, President Biden then eventually vetoed that repeal under the Congressional Review Act, as he said he would, and it's unlikely that it will overcome the 67 vote threshold that they would need to basically override his veto. But the important thing there is establishing a marker and a potential 60 vote coalition for an eventual bill on crypto and digital assets, because that's really going to be the most important thing. We have seen a lot of bipartisan deal making in the House. Obviously, Fit 21 passed, and there were significant amounts of Democratic co-sponsors on that bill, as well as Democratic votes. There were a lot of Democratic votes in the House for the repeal of SAB 121. One of the problems is, though, for any of these bills, you need to get over that 60 vote filibuster threshold in the Senate. But I think what a lot of crypto advocates and crypto people that want updated crypto policy and regulation on digital assets should really focus on is the fact that there was 60 votes for something. Now, maybe there's not 60 votes for something like Fit 21. There's some jurisdictional issues we can get to into the Senate as to why that bill might not pass the Senate. But still, it kind of shows the roadmap for the future as to which votes are gettable for a crypto and digital asset bill, even if we don't get it in the next few months before the election. Going into whoever is the next president, be it if it's a second term for President Biden or if it's a second term for former President Trump, for either of them, there will be a push to try and get some kind of crypto and digital asset regulation in the early part of the first term, well, second term for either of them once
Mhm.
they come in. And one of the reasons for that is typically when we see this, there's typically a united Congress that comes out of these elections. Usually they're decisive one way or the other. And if either of the parties were to get a trifecta, that would increase the possibility that you could get actually some kind of legislation through.
Mhm.
And then we, again, just have to kind of see what the makeup of Congress will be. But that's the thing I think it's really important to understand is that some of these bills are more just putting markers on the table rather than a realistic chance of passage. But that's not to say that these aren't the seeds that will grow into the eventual legislation and regulations that we might get.
Understood. And you raised a really interesting point there, Adam, that even just having these types of conversations and these bills get drafted, go into committee, out of committee, get forward, put for votes, and actually get votes on both sides of the aisle is in and of itself a much improved outcome as opposed to just a couple years ago. Um, and so, on the other hand, right, there has been this attitude that I think is pretty well understood, and I won't ask you to add any other commentary to this, that the SEC has not always been open to more crypto products and more instruments entering the marketplace. But and obviously this has been sort of an ongoing process, but there is a pretty firm market sentiment that by mid July, a ETH ETF product will be approved and issued. So I was just interested in sort of what your thoughts are on sort of that whole process and really honing in on the possible impact of an ETH ETF being added into the financial landscape.
Yeah, I mean, I think the most important thing on the timeline, at least, is to go by the chairman of the SEC statements. He did
Mhm.
testify before Congress last month. And one of the things he did note is that he was saying that these ETP products were going through the normal process. Obviously, the S1, the rule books for the different exchanges were approved to allow for these products. Now you need the S1s for the individual funds themselves to pass SEC muster, and then that's what would allow them to be listed. He stated that this was going through the somewhat normal process, and I think we saw something similar with the Bitcoin ETFs and Bitcoin ETPs when they were approved.
Mhm.
And one thing I have heard is there's much more good faith interaction between the lawyers pushing these S1s and the SEC staff. I know in the past that there had not been much of that on these applications, and I think that was something we also saw in the run up to the Bitcoin ETPs being approved, is this honest exchange of information back and forth. If the SEC is preparing to approve something, they will have some questions. They will want to get those questions answered. There will be a good faith process back and forth, and then eventually they will go forward. So that is something I would expect possibly even this month, but by the end of the summer, by the chair's words. I think one thing to really understand is, at least the way Chair Gensler would state it, they feel very constrained at the SEC by this DC Circuit opinion that around the Bitcoin ETPs when they were sued regarding that, where basically the DC Circuit ruled that if you want to deny these applications, you need a fact-based reason to do so, and this is based on the principle that you must treat like as like.
Mhm.
And the main thing the DC Circuit pointed to is that the SEC determined, and this was under a previous SEC administration during the Trump administration right at the end, but the SEC did determine that there was adequate price discovery in the futures market for Bitcoin to allow for an ETP ETF on the Bitcoin futures market. What they said is, you have not provided us a fact-specific determination as to why there is inadequate price discovery in the spot market, but you do find there is adequate price discovery in the futures market.
Hmm.
This provides the exact same roadmap for getting the Ethereum ETF and ETPs passed, because there are Ethereum futures ETFs and ETPs. And one thing I've tried to note to people is, the SEC staff only has so much bandwidth.
Sure.
And if they really wanted to deny these things, to come up with a fact-specific record for every single one of, I think there's 11, potentially up to 20 if Ethereum ETPs that want to launch, and then there was obviously over a dozen Bitcoin ETFs and ETPs that wanted to launch in the spot market. To do the kind of fact-specific record and documentation that the circuit court demanded would potentially take up all the staff bandwidth for the entire SEC registration staff. And as we know, the SEC registration staff is quite busy. They're not just involved in the digital asset market. These ETPs and ETFs are not their only responsibility. They have to review numerous S1s and other regulatory filings for just typical securities in the securities market. And they really do have to prioritize their resources. And so I think what you're going to see is very similar with the Bitcoin example. They will find some unified rubric to approve all of these S1s at once, basically say they all have to have certain common elements,
Hmm.
and then approve them in mass. And one of the reasons to do that is, again, you don't have to go through this fact-specific determination and develop a substantial record for each application, which would bog down the agency. Now, for anything outside of Bitcoin and Ethereum, you might have a little harder time getting those ETPs and ETFs approved, only because you don't currently have those approved for the futures market. If they had something similar like those, then you could potentially see a path. But it will, I think, be harder for future applications outside of these two asset classes. And one thing that I should note is, at no point has the SEC, in their numerous litigations against different companies around securities violations in the crypto and digital asset market, ever identified Ethereum as a security. They have identified numerous other cryptocurrencies that they believe to have the nature of a security or investment contract, but have never once said that Ethereum is in a court filing. Similar, they've never said that for Bitcoin either. So it does actually put these two, and obviously the two largest cryptocurrencies, and in the digital asset class, I think they make up over 50% between the two of them.
Hmm.
They do seem to be a bit unique from all the other altcoins that could potentially would want to get in the future pipeline. And I'm thinking the Litecoins, the Dogecoins, the Solanas, the other ones that would be the next natural step after you approve an Ethereum ETP or ETF. Those might have a harder path going forward. Let's say if Biden was to win a second term, you could still see hostility at the SEC to these kind of applications.
Gotcha. Gotcha. Okay. Well, having that insight, and really that makes it a lot clearer for me to understand sort of how we got here, and then sort of why, after really multiple years of saying no to all of the previous Bitcoin ETF applications, that frankly they got approved all at once in January, and that same model could be used going forward for the ETH products. And so, to obviously any conversation that's around policy and U.S. policymakers around crypto does have to talk about FTX, right? And even though that trial is over, and there were all sorts of optimistic estimates now on the value of the bankruptcy assets, which is all good news, I would say.
Definitely for the creditors.
Yes,
It's one of the.
definitely for the
I
creditors.
think it might go down. I would have to check this, but it might be the first bankruptcy in history where the assets, by the time they were distributed, were worth more than when the firm became insolvent. I think if
Huh.
you were doing current mark to market, FTX would not be insolvent based on the assets they had available at the price they're at now.
And that is a interesting twist that I'm sure quite a few bankruptcy lawyers are going to be,
Yeah, I
thinking
think you
about,
could
talking, working
expect to
on for
see
a long
some
time.
papers and studies on this
Yes.
bankruptcy going forward. It's one of it. I don't think most bankruptcy experts ever go into a bankruptcy thinking that there's going to be more assets available to cover claims than are available. That's not something that usually shows up in bankruptcy, but clearly is the case in this one.
Yeah. And so, from a policy conversation point of view, obviously after the collapse of FTX and all of the criminal wrongdoing that was uncovered at the entity, is is there still any sort of FTX hangover in terms of policy conversations and in terms of what types of companies in the crypto space are more likely to succeed in their conversations?
So I think two things are important to point out with the FTX collapse. First off, the two major regulated entities that FTX had, which was their CFTC FCM in the United States, Ledger X, that they acquired through an acquisition, and FTX Japan, which are both governed by strict regulatory regimes with capital requirements. Neither of those failed. Neither of those companies became insolvent. No creditors lost any money with those two entities. I think everyone in FTX Japan and everyone that was a customer of FTX in the United States got their money back. The people that didn't were the ones that were of the parent company in the Bahamas, and or at least haven't got their money back yet. I will caveat it
Mm-hmm.
again. The assets have now appreciated in value. Everyone is hopeful that they will get a distribution that will make them whole. But at least at the time, their money was obviously locked up and their assets were locked up, and that's not something anybody wants. So I think one lesson that at least Democratic lawmakers learned from that, and many Democratic lawmakers definitely felt burned by the whole FTX situation. Maxine Waters, plenty of the other people on the House Financial Services Committee and in the Senate had taken donations from SBF. They had allowed him to speak at different committee hearings, and he was obviously a prominent promoter of the crypto legislation that he favored. With the instant clearing model at the CFTC, they proposed some novel things, and they were one of the biggest lobbyists in the space at the time. One lesson I think many of the Democratic lawmakers learned from that is that regulation, in their view, is essential. They view that one of the reasons FTX failed is there wasn't adequate regulation and enforcement. They moved offshore to get a less strict regulatory environment in the Bahamas, and look at what happened. They blew up.
Mm-hmm.
So I think that's one lesson the Democrats at least learned. And Democrats are obviously more prone towards regulation. GOP by default is more prone towards deregulation. So I think what it did was more put the parties in their traditional camps,
Mm-hmm.
where the Republicans are still pushing a more deregulatory stance. And you could see that in Fit 21, the bill that passed the House. What they tried to do there is to get around some of the jurisdictional issues in the Senate instead of making the CFTC or the SEC the lead regulator. Obviously, they gave most to the CFTC. They empowered the Commerce Department to run this, basically
Mm-hmm.
saying, okay, we're just going to avoid this jurisdictional fight completely. We're going to give it to Gino Raimondo like we did with the Chips and Science Act. We're going to allow for innovation and fostering innovation and let the Commerce Department figure this out. So that is just one way in which kind of the ball has moved forward.
Mm-hmm.
Obviously, it empowered some of the biggest crypto critics in the Senate, let's say the Elizabeth Warrens of the world, to
Mm-hmm.
basically say that just like in the 2008 financial crisis, you can't leave these people to their own devices. They get too greedy without regulation. You'll see these different kind of collapses that hurt consumers. So I think her hand was strengthened there.
Mm-hmm.
And I think now that is somewhat the default position on the Democratic side, that there must be some kind of regulation. Obviously, they favor a more heavy touch regulation than the Republicans do, but kind of some of the deregulatory hopes of the crypto industry and digital asset industry during the FTX period. And that was one of the times where this long ballyhooed stablecoin bill that she's been negotiating with Patrick McHenry in the House Financial Services Committee,
Mm-hmm.
there was real hopes that that was going to come out with a draft, an agreement between the two of them, could potentially get out of the House, and at least we would get the stablecoin piece regulated, which seems to be low-hanging fruit. Those have dissipated since then, and I think it will take the Democrats some more time to get more comfortable with any kind of deregulatory pushes in the area, only because even though we're farther out from FTX, it's still pretty close.
Mm-hmm.
And you got to remember some of these congressmen and senators, there are personal feelings here now. They met with
Yeah.
FTX personally. They felt they were lied to. They felt that they thought they were dealing with a good, smart actor who was supposed to be seen as the poster boy for the industry. And it turns out he was a fraudster. He's now in jail. it that takes a long time because again, now it gets personal. It's not just a policy decision. It's not just a discussion. These people actually felt hurt personally and felt that their personal brands took a hit because of this association. And again, I mean, these are politicians with egos we're talking about, so you really don't want to bruise
Oh, really,
the ego.
really egos, Adam? Egos are
I know, right? An
involved in
ego for
this?
a politician. Who would think it?
No, and really, excellent insights there, Adam. And I'm sure that the audience tuning into this episode is definitely gaining more insights and more sort of just or rather getting a more comfortable feel for how all of this stuff goes, right? Because for somebody outside of the policy world, the regulatory world, it can all seem sort of opaque. So I have one last question for you that I had not prepped you on. So I'm going to put you on the hot seat here for our last question here, Adam. You know, what do you think the first, and I guess I'll borrow the words of a landmark piece of regulation for U.S. crypto companies, issuers, investors is actually going to be? Like that first big piece that makes it easier going forward.
So one thing I want to know, and I mentioned this previously, I just want to make sure I get back to it. And for people that
Sure.
might not understand this, this is a kind of a key quirk of Senate jurisdictional politics that really is guiding this entire discussion, and almost no one knows about it. I know about it only because when I worked in the Senate for Senator 11, his fellow senator from Michigan was Debbie Stabenow, and she was the head of the Ag Committee at the time. And so you really do learn about these jurisdictional issues. So the
Mm-hmm.
main thing to understand about this topic is that there's a key jurisdictional fight between the CFTC, which is our traditional commodities regulator, and they report to the Agriculture Committee in the United States Senate. And the reason for that is initially futures and commodities were done on traditional commodities. We're talking grain, oil, and everything. That's the reason they report to the Ag Committee. Obviously, that's changed much in the subsequent decades, but it has not changed the jurisdiction. The
Mm-hmm.
SEC falls under the jurisdiction of the Banking Committee, which makes total sense. SEC, most financial regulators go to banking, makes sense, goes there. One thing that key to understand, though, is anyone who is the Agriculture Committee chairman loves the fact that the CFTC is in their jurisdiction. One
Mm-hmm.
of the reasons for that is pretty simple: money, campaign donations. If you're the head of the Agriculture Committee, you get donations from all the PACs related to agriculture and farming, but you also get donations from all of the PACs in finance because almost all of them deal with futures and derivatives, and they want to have say in any potential CFTC policy. So it's kind of a double. If any regulation empowers the CFTC, which we've seen in numerous proposals, let's say Lummis Gillibrand, one of the big things is it really beefs up the CFTC budget because
Mm-hmm.
currently the CFTC doesn't have a robust enforcement staff like the SEC. They have a pretty small staff. Most of their enforcement actions rely on their self-regulatory organization, which is on the SEC side, that's FINRA. On the CFTC side, that's the National Futures Association, which is the Association of Swap Dealers, FCMs, and other CFTC regulated entities. Those are the people that actually do most of the enforcement on the CFTC side. And one thing to know is the CFTC is a derivatives and futures regulator. They've never regulated a spot market before. So if you
Mm-hmm.
give them the crypto spot market as a regulator, this is something completely new to them. So they would need additional staff just on the rule and policy making perspective, but they would also need additional enforcement staff. And so one of the things you see in these bills is a big plus up in their budget. The banking committee doesn't like that. The banking committee does not want to cede any of the jurisdiction. They want this to be the SEC because that means if this is all regulated by the SEC, then all the donations go to the banking committee. If you sit on the banking committee, it means you get more campaign donations. So trying to work our way through this Gordian knot of who is going to be the regulator or who's going to be the primary regulator is one of the most difficult questions we deal with here, and no one really knows why that is, and that's the reason. It really comes down to campaign donations and money and the way these agencies were originally set up and which committee they report to. So laying that out there, one thing you've seen is, let's say in Fit 21, as I mentioned, the House just was like, we can't solve this. Throw our hands up, give it to Commerce. So let's not even
Mm-hmm.
let's not even go with the fight. Let's not pick one or the other. Obviously, they give a little more power to CFTC, but let's take it out of the hands of both of them and give it to the Commerce Committee. So I think what you're going to see if you're looking for legislative action, the most realistic ways are things that don't engage with that jurisdictional fight, because I haven't seen a good answer yet on that front how we're going to solve that problem. Maybe one will develop in the new administration. I've not seen it yet. So what you have to think of is what can pass that doesn't require getting into that fight at all. So that's one of the reasons people were really hopeful about the stablecoin bill, because that traditionally would be regulated by, let's say, the FDIC or Federal Reserve. There's not this huge jurisdictional fight. Seems like low-hanging fruit. If we can get some agreement on how to regulate stablecoins, maybe it's a foot in the door to start building a regulatory apparatus around crypto and digital assets, and gives more time to solve that jurisdictional fight. Additionally, which might not be so great for the industry, what I've always thought is the most likely area where you do get some policymaking or new laws is around KYC, AML, anti-money laundering legislation. And one of the reasons is you can house that as a national security issue. So basically fighting sanctions avoidance, anything like that. And that makes it much easier to get something passed if you can slap national security and national defense on it. You can put it in the National Defense Authorization Act. That is a must-pass bill that passes every year. And that has seen, and what we have seen is we have seen some legislation go through that. For example, the crypto tax provisions that are now coming in, many of them started in the National Defense Authorization Act, dating back to when Trump was leaving office. And then additionally, in some other bipartisan bills, such as the infrastructure bill, there's a pay for around the crypto broker taxation. So that is a way to sneak in regulation in the space. Basically, let's say, could you extend Bank Secrecy Act, KYC, AML obligations that are on banks to crypto and digital asset companies? As I said, that may not be positive for the space, but could lead to wider acceptance in the financial industry if you had some of those additional requirements. But you also could see a more lighter touch bill, something maybe a stream down FIT 121, something like that, a FIT 21, that really empowers the Commerce Department, let's say from the Chips and Science Act, from the innovation perspective, gives them like a pot of money or grants to foster innovation in the space without addressing some of those larger regulatory issues that we discussed.
Okay. Well, as you I think aptly put, it really is a pretty naughty situation in terms of how to actually sort of on the one side sort of technically have the right bill put forward, but then actually trying to push it through the hot dog making process is a whole other aspect of it that honestly, Adam, I didn't really know all of that backstory in there. And so now it's a lot clearer to me, as to why there is so much backing and forthing, right? And so much arguing over who's in charge of what, and then which committee or which agency gets to oversee which aspects of this whole space. But Adam, it has honestly been an absolute pleasure having you on the podcast. I will definitely ask you to come on as we have some updates on these things, probably, and especially after that pesky little vote we have coming up in the fall. But Adam,
yeah, it could potentially mean a lot for crypto policy one way or the other. So we didn't get a mention of it at the debate, but hope springs eternal. There's potentially another debate in September, maybe between the two same candidates. May not happen.
Hey, maybe.
Another candidate, and maybe crypto comes up this time. We'll see. It's definitely a topic I know everyone was intently listening, and then the debate really kind of went into many areas I don't think anyone was expecting, and it seems crypto may have got left off the board, but maybe for next time.
Yeah. And Adam, I will absolutely ask you to come back on again. It has been an absolute pleasure having you.
All right. Well, thank you so much. This was great. Thanks so much, Sean.
All right. Thank you again.